A lot of employees thinks that a severance package is a parting gift from their employer when quite frankly it's the opposite. Hidden fine print, reasons to sign away your rights, your value and more happen. And that's what we're going to go over today is those main red flags to look for before you sign any severance agreement in front of you. Hey everyone, it's Acacia, the CEO legal coach. And if you're new to this, I am a longtime attorney, business advisor for about 15, almost 20 years. And this is the Aligned Business Series. We go live 3 times a week, Tuesdays, Thursday, Fridays, 10 a.m. Pacific time. And I answer your questions live. Okay. So if you haven't found your chat button, make sure you do find it and add your questions to anything that's coming up in today's call because I want to make sure you have what you need to succeed in the world, especially when you're dealing with a severance agreement. There's so much stress, so much panic, so many things that are put in there intentionally to distract you, right? They know that you're going to freak out that you're losing your job or you're losing that steady paycheck. Now, of course, 10 to 20% of people are like, that's okay. I have the money, or that's okay. I was going to start my own business. But what about everybody else that really relies on that paycheck or just wasn't ready to let it go? They know that by putting a few extra dollars in front of you, you're going to be distracted and want that and sign away things that you didn't realize you were signing. So today we're going to go over 6 key ones, okay? 6 key areas of red flags in severance agreements. There are more. When I was making this list, I was like, how do I keep this under like the 20, 30 minute with the Q&A? Because over the years, I have seen some serious red flags. And let's just start with the one that affects your pay. This one is one of the very first ones I see in a lot of agreements. And that is how the actual word they use to describe what you're going to get paid. The word they use, it's usually a vague or generic term. Like you're going to get 8 weeks worth of salary. Salary. What does that mean? Does that mean just your base salary? Does that mean your salary plus your average commissions? Your salary plus what would have been your annual bonus? What is determining this number? This is something that they intentionally leave vague because then they can go to the lower side and be like, well, you were okay with salary. And you'll be like, yeah, my salary is like 20% of my actual paycheck. I expected the rest. So the first red flag is just even making sure that the term they're using for what they're going to base your payment number on is not generic. That is specific. You know exactly what you're getting, what's included in that, your bonuses, your commission. What about the stock you had before? Is it going to finish vesting? Everything that you've been paid over your time there, go back and look if you can, or scan your memory, definitely for the last year. What was included in all of your paychecks? And make sure that whatever term they're using, your pay, your salary, whatever that is defined. That is a defined term. You definitely want that term to be defined, okay? Because if not, they can just say there, like, for example, I was in sales. My base salary was like, I don't know, 20, 40% of what I took home. So if my severance agreement said my base salary, well, they're missing 60 to 80% of what I was actually taking home, what I'm used to making, and so on. To where I actually, number-wise, would have been better on unemployment because I would get a higher percentage than what they were going to pay me in severance. So that's the first red flag in your severance agreement, okay, is whether or not there is a defined, clarified term, usually not, and you want to get that extremely clarified, okay? Now, the next red flag I see a lot. Hey, Mary. Hey, Bob. I see you guys. Yes, welcome. I will definitely keep answering your questions, so get them in the chat. So the other red flag that I decided to focus on today, like I said, we're going to go over 6 of them, is the difference in your non-compete versus your severance pay time frame. The difference in your non-compete versus your severance time frame. Now, non-competes vary in laws, just state to state, which also means it's going to vary what your employer is asking of you. But what I have seen is, let's say you have a non-compete that says you can't even apply for things in your industry for 6 months. Okay. Well, but they're only going to pay you severance for 2 months. Well, okay, so I can't apply for a job in my industry for 6 months, and then it's probably going to take me another month or 2 to get a job, and you're only going to offset that by 2 months of severance pay? That doesn't feel right. So understanding that balance of what is being asked of you in your non-compete, what opportunities does that allow you to do in the time frame? Like again, let's say yours was 6 months, but I have seen them up to 2 years. I have seen them up to 2 years long. What is allowed in that? Are you reasonably going to be able to find another job in that time? If not, they need to pay you for that because that's a benefit they're getting. They're holding you back from going to a competitor or a vendor or a supplier or a client. Well, if that's a right they want, they need to be paying you for that. And they need to pay you a severance that balances that weight to you. Because otherwise, you're going to not be able to get a job and not get paid. That's not really a fair exchange. Okay. So that's the second main difference I see is the value, the limitation, both in time and scope of that non compete are not aligned to the severance time frame. So make sure that that is clarified and if you need to go back and negotiate. And you can negotiate either the non-compete to be more open, be like, "Hey, you either need to reduce this down to 2 months. You need to open it up so I can apply to these types of employers or you want more pay." Right? So get what you need out of it, but it's a value exchange. So you have both sides of that. You can negotiate the non-compete and you can negotiate the severance pay. My opinion, do both. Do both. Why not? Right? What's the worst I can say? No, the terms are what they are. Well, then you know not to sign that. Okay, so our third one now is, and you know what? I didn't put this up. Let me put this up. So, those of you who don't know, I have a program called Severance Studio where I literally break down for employees that have been recently laid off everything I know, everything I've ever learned. I put it in there and it's meant for employees, right? This isn't legal jargon. This isn't legal. This is to help you review and quickly get through your severance agreement, making sure that you're not being taken advantage of and you can get the best that you can, or at least what feels right to you. Okay. So the third thing, and this one just happened to a client this week, the third red flag when it comes to your severance agreements is the timing of that severance pay. The timing of that severance pay. Why does this matter? Because if you're on unemployment and you suddenly get a bonus check from that employer, well, you can't be on unemployment anymore. You just got payment. So we want to understand, like a client I had this week, he's like, "Hey, my severance pay was supposed to be like 2 or 3 months after, but then I went back. I talked to him. I was like, let's go get your bonus brought into this." Right? So he's like, went back to the employer. Was like, "I want to negotiate my bonus into that definition of severance pay, that salary," and they were willing to consider that. But they're like, "Not a problem, but we're going to pay you your bonus in like the February, March time that we normally would." Well, his state has 6 months of unemployment. So if he gets paid those 2 or 3 months plus the 6 months and he'll be on unemployment, assuming he couldn't find a job or his non-compete was 6 months. In the middle of that, he's going to suddenly get a bonus check. Well, that's going to stop the rest of his unemployment. So we cared about the timing of those payments. It sounds great, you're going to get your bonus, but you want to make sure that it's going to be in a time frame that's not going to knock out other money. That's not going to knock out other benefits in your state. So be mindful of what is being paid when and how that's going to affect any unemployment that you might have access to or rights to after. Okay. So that's our third thing. The next one, I got to say this, it amazes me because this one is super important to me. Super important to me, but I've never really had my clients care about it. And I find it so interesting because as a lawyer, this is one of the most important things to me. And I think that's because I understand it differently than the average person does, right? The average person, you probably care about the money. You probably care about your benefits. You probably care about getting that next job. Top 3 priorities right there. Yes, very, very important. And I want those to be your priorities. They are priorities. But when it comes to a severance agreement, what you're really doing is a value exchange. There's a value exchange. And so far, 10 out of 10, but I'm going to say 9 out of 10 times, you're waiving rights to sue them. You're waiving rights to sue them. And that's normal. That's a normal ask. And I'm not opposed to waiving rights for things up to what's happening. Okay. They don't want you to sue them for the way they're laying you off. Okay. That makes sense. You're going to get a paycheck, the severance pay in exchange for not suing them right now. Okay. You know whether or not you want to waive that right. You know, if you have any reasons you might want to sue your employer for whatever reason, it doesn't even have to be related to this. You know this. But what happens so many times on severance agreements is future things. future things you may not know about yet. And I'll give you an example. Let's say, so right now your employer probably has a picture of your IDs, like your passport, your driver's license, social security card, whatever documentation you gave them to be employed there. And they hold that because they need that for government purposes. They have your social security number. They have your bank info. That's how they give you your direct deposits. They have a lot of info on you. And let's say that there is a data breach. A data breach. It could be this week. It could be in 2 years. But you don't know about it. You don't know about it. And let's say that ends up with some massive fraud against you. That ends up with you losing money out of your bank account, whatever. That could be really, really harmful depending on who gets the info and how they use it. But if you've waived future rights, you can't do anything about that. You have to sit there and suck it up. You don't get to sue your employer. Most of the time, with the way I see how broad these are written, you wouldn't even get to go after the hacker. You're stuck with that because you waived future rights, rights to things you didn't know, rights to things that hadn't even come up yet. So when we're looking at our severance agreements, I do think it is appropriate and a fair value exchange, my personal opinion, you can decide for you, to waive rights to sue about things that you know about. Waive rights to sue about things up until the date of the severance pay. But future things that you don't know about, you don't know the value. You don't know the value of that, so you can't get the value of that. You can't say, well, if this hacker thing situation happens, that's worth $500,000 to me. Odds are you're not going to get $5,000 extra in your severance pay right now, but that's what you gave up. And it could be something else as simple as like, oh, they find out they had lead paint in the office and now we're in a class action suit because a lot of people had this outcome from that. Well, you can't be part of that either. And so it doesn't matter what type of case it is. It doesn't matter how big or small. It doesn't matter if it applied to you or all the employees. It doesn't matter. You're waiving future rights, which means you're waiving things you don't know. And that's why I don't like them being given up, is because you can't put a value on that. You can't put a number on it. You can't put a real analysis of what this means to you and your family. So that's one of the other red flags, okay, is that waiving of the future rights. It is very common and acceptable if you feel that you would rather take this money than sue your employer for things that you are aware of. That's normal to ask for in a severance agreement by your employer. But do know, you don't have to sign this agreement. You do not have to sign it. But if you don't sign it, you don't get the value exchange. So you won't get that severance pay. So if you have any intent on suing, or at least want to explore suing your employer, get an employment lawyer in your state now. Now. Get in there and get that consultation. Get an idea of, do you have a strong case? How much money would this case be worth or not worth? And then you could decide against the pay they're offering you. You get to balance that, okay? And we go through all this in the Severance Studio. There's an entire module just on waiving rights, All right, number five on our list, the fifth red flag. I mentioned it indirectly earlier, and that's overly broad terms in your non-compete. Overly broad terms in your non-compete. I have seen such overly broad terms that a person couldn't apply to anything in a 200-mile radius of where they lived, a 200-mile radius of any office, and anything literally in the industry. It even said the word. There was a particular, it's like saying you can't do anything in IT. They literally said that. It is like, what is this person supposed to do? What is this person supposed to do? And then it also said you can't reach out to our suppliers. You can't reach out to our vendors. You can't use any of the relationships you have. You can't do anything. He was just like, can I do anything? Can I do anything? So non-competes, this is really important to know. Non-compete laws vary state to state. And this can be really, really difficult. So last year, the FTC tried to ban non-competes across the board because there were so many employers who were being abusive and overly inclusive in their language. Overly inclusive. It's like, do you really need to prevent your employees from ever applying to a place within 200-mile radius for 2 years? And they can, you're basically preventing them from making a living. So the government tried to step in. It got overturned in court. So it's back to every state gets to do their thing. Some states, your employer can get away with almost anything on that paper, which is why it's important you negotiate it. It's important you negotiate it to what matters to you. What do you need to do? Even starting your own business might fall into that non-compete, probably does. Where other states, I think California, I'm not licensed in California, but I think California is one of the most favorable to employees, where the employer has to demonstrate that it's necessary to protect their business to have these limitations. Now, what's really important to know is if you have any doubt that your non-compete might be illegal in your state, don't sign it, because you're still signing an agreement, a contract. You still have a contractual bound. And no offense, but you're not the one to determine whether or not it is or is not illegal. So what would end up happening is you signed it, you're in breach of contract. You're in breach of contract the second you violate it, which number 6 we're going to get to. I was going to be like, it's going to hurt. And then you've got to go deal with a cease and desist. You might lose your job that you got over it because your current employer is going to tell your future employer, by the way, this person violated this. So you're going to lose that job, and then it becomes a mess. And then you're involved in court potentially, legal fees, all this stuff. And even if you win and you were right that non-compete was illegal, you just had to go through all of that chaos to get to that point. That sucks. So the best thing to do is, if you have first, just try to negotiate it. Just try and negotiate it. And if you have any doubts that it might be illegal, then use that as leverage. Like, hey, I believe you're pushing, I don't know, Massachusetts state law about this, or Illinois state law about this. And so I want this reduced. And of course, get an attorney involved if that is what you think is going on, especially if your employer is not budging, if they won't open up that non-compete to allow you to make a living. All right, number 6. Are we ready? Okay. Clawback provisions. This is a red flag for you. It's a red flag for you. It is normal to see these in there, but they don't have to be in your severance agreement. And it's not going to usually be called a clawback provision. But what it does is it says, if you violate this agreement, like we just talked about, if you end up applying for a job that you weren't allowed to apply for thanks to your non-compete, if you end up getting employed and you don't tell them, well, they can take your money back. This is the importance of a clawback provision. They can take the money back in certain situations, and they put it right in the document. So you want to be mindful. Do you have any of these? You want to be mindful if you have any of these. There's another one. It's not a full clawback, but there's a cutoff. And that's if you get employed before the severance ends, 8 out of 10 times you have to tell them and they get to stop paying you. Right? They can take the money back in a lot of situations, or at least cut you off from it. So these are a red flag you want to be aware of, especially if there's any language in that document that you're a little wishy-washy about, okay? You want to make sure it gets clarified so that you're not in violation of any of these things, okay? So that's the 6 main things that we went over. 1, you want to make sure that the definition of pay, your salary, whatever vague term they're using, is clarified, because they will default to the absolute lowest amount that they can pay you for it. 2nd, you want to know the difference in your non-compete versus your severance pay time frame. Very important, because you might end up going unpaid for part of that. 3, the timing of that severance pay and its impact on unemployment. What is convenient to your employer might actually cut off your benefits. 4, we talked about waiving those future rights. It's impossible to put a value on it. It's impossible to put a value on it. That's why I don't like it on the page. But a lot of my clients just seem to go with it and pray for the best. I leave that up to you, of course. But future rights could be worth millions. Don't let them, but you just don't know. You might know. And nothing might come along, or something major might come along. 5, those overly broad terms in your non-compete, they can prevent you from applying for a job, getting a job, and then they cause a big bunch of chaos, and you might end up losing that new job over it. And last but not least, those clawback provisions, where the employer can come in, take the money back, cut the money off, all of those types of things. Like, you'd be like, well, I paid it to mortgage. It doesn't matter. You owe it back. Like, that sucks, right? So don't let that happen to you. All right, I see questions in there. Let's get to those questions. Hey, Asser. Hey, Emmy. Yes. Oh, thanks for being here, guys. I love it. I love you all. Thank you. Oh, thank you. Yes, it is a different color of lipstick today. Let's see. If my agreement just says salary without a number, should I sign? It's not whether or not you should sign. It's that you want to know what salary means. What does that mean? Salary. If you've only just had one base check, that's fine, right? It's not a big deal because there's only one number it could be. But if you make commission, if you make any type of like percentages off of certain sales or kickbacks, that's not the right word, but also bonuses. Like, what about your annual bonus? Like I said, my client right now, he was up. There's the opportunity for his bonus to be added in. We were talking about that. He went to the employer's looking at it, but when does that get paid? How does that get paid? They weren't going to pay that. So understanding what the number means, that's what's important here, because we don't want them to default to the lowest that they could pay you. Well, that was your base salary. And you're like, my base salary is worth 10% of my annual take home. Like, what the heck? You want to really know what it means. And then the other thing is, you don't have to sign. You do not have to sign if you're not comfortable signing, right? If they want you to sign, if they want you to waive these rights, they need to make it worth your while. Know that, okay? But also know if you don't sign, you don't get those benefits. Yep. Can I ask them to add the exact dollar amount into the agreement? I mean, an exact dollar amount is a lot more clear than salary, pay, so absolutely. If that's what you want to do, then do that. Sure. Why not? The thing is, before that number gets calculated, though, make sure it is accurate. Make sure that is the full number that you actually truly want. What if my severance lasts 2 months, but the non-compete is 12 months? Back to both sides of that are negotiable. Both sides of that are negotiable. You can get that severance to last longer. You can do that. You can get that non-compete to be shorter in time frame. Hey, 2 months of pay. Well, I want a 2-month non-compete. Or what you could do is negotiate how broad it is, right? It might be 12 months, but it simply says you can't go to our 3 main competitors. That's not very limiting. That's not a very limiting one. So even though it's 12 months, you can't go to our 3 main competitors is small. That still leaves a lot of places for you to go to get employed. So it's not really unfair. So it's the overall scope and impact of the non-compete. Is it that you can't apply anywhere, or is it that you can't be hired anywhere, or that you can't start, right? We can interview, we can get hired and just push our start date back. Versus, and how broad is it? No jobs within 200 miles of where you live, or just nobody that's our 3 competitors in your area. So look at how broad it is, what they're asking and restricting of you, and what that means for you. What do you want next? Some people want to go start their business. Okay, well, does your non-compete allow you to do that? Other people just want to find another job. Okay, does your non-compete allow you to go to the type of employers in your area, or the type of employers in your industry that let you work hybrid or remote or whatever it is you need? See what's out there as your opportunities and compare that back to the pay. But know that both sides of it, absolutely negotiable. Do all severance agreements include a non-compete? I have yet to see one with that one. But what I would say is sometimes it's not in the severance agreement. Sometimes it was in your offer letter. Back when you signed on and you're like, yes, I want this salary. Let's start. I'm so excited. And that could have been years ago. There might have been a non-compete in that. And then what they do is they attach that to your severance agreement. As a friendly reminder, don't forget you have this. So where it is different than does it apply, right? Does it include there? Even if it was in your offer letter, you still get to negotiate it now. Saying, hey, you're letting me go for this severance. I'm only going to sign this. Remember, it's optional to sign this agreement. They want things out of you. They want you to waive your rights to certain things because it's in their interest to pay you, not to sue them. Suing costs a lot of money. And so if they can give you a fraction of that and get you not to sue them, that's a big deal to them. Saves them a lot of time, a lot of headache. It's going to save you time and headache. It's worth it. So look at that. Where is the non-compete? And let's say you had a really, really broad one in your offer letter. It is okay to ask to negotiate that down in this document. Bring it down. Now, one thing to know about everything we've talked about, and this is definitely in the Severance program, right? The Severance Studio program, where I break everything down by money matters, by insurance. We go through a lot about your insurance because there's stuff about insurance you don't know what's happening. Your waiver of rights, what are you doing, and the overall value exchange that's happening. Each one of them has a module and checklist and stuff in Severance Studio. So if you're facing this, know that there's a resource for you. And one of the things we talk about in that is the idea of the entire agreement clause. They're 99.99% of all contracts in the United States, not just severance agreements, but all contracts, how it's called an entire agreement clause. And what that means is anything you get in an email, anything you have in those conversations, confirming with HR and your boss and all those things, they don't matter. So even though you're like, oh, we're negotiating what the word salary means, that's going to include commissions and bonus and blah, blah, your email doesn't matter. You need it literally written in this document. It literally must be explicitly stated in this document. Otherwise, that entire agreement clause, that's what it's called, entire agreement clause, will push it out. An entire agreement clause in a contract, what it does is it says only what's written on the four corners of this paper matter. If it's not on this paper, we have decided that it no longer applies to the situation. Okay. And because you'll be signing after all those emails and after all those clarifications, you're signing that those things didn't matter, that you got everything you wanted and needed on this piece of paper. So everything we're talking about today about that non-compete versus the severance pay, the definition of salary versus anything else, you want it explicitly put on the paper. It is not enough to have that email from HR or your boss. I think there was more. Did I find? Oh, I love you guys. Thank you. Happy Thursday to you. If I sign, can I sue later for unpaid bonuses or overtime? Majority of the time, no. Majority of the time, no. Like I said, it is normal and expected that every severance agreement, you're giving up your rights to sue up until the date of severance pay for everything. The question is whether or not future ones are. Now, that being said, there are certain rights that are under federal law, which, by the way, is not as protective, is a lot harder to prove. It has a completely different standard. It's not very employee friendly sometimes, if I'm honest, that you can't waive. So they're not allowed to make you waive those under federal law, but that doesn't mean something that state law doesn't apply. So if you have any concerns about potentially suing your employer, go talk to an employment litigation law firm immediately. Immediately. Here is why. You don't know the value of your lawsuit. You don't know how well you're prepared to prove it. Even if they did, in fact, violate the law, being able to prove it at court is a different question. So then what you could do is a lot of law firms give you like a free consultation. Go talk to them. See what it would take to sue them. See what it would take, the likelihood of outcome. Are you likely to win? And if so, how much? Because now you could see that even if you have a lawsuit, maybe your severance pay is better or better off, right? Lawsuits can take years. It's exhausting. And it's going to be out of your pocket to make that happen up front, depending on the case, right? Some law firms will foot the bill for you and then just take that out of your winnings. But you want to know that now. You want to know that now. So do not sign a severance agreement at all. This is why you get that window of time to review it. You get that window of time to review it because you are waiving rights. So this is your time to explore them and then see. So if you have unpaid bonuses or overtime, first off, know that anything they owe you, they cannot withhold from you. If you've earned a bonus or you have overtime from last month that's owed to you, your severance agreement is not allowed for you to waive that. They owe you what you've paid, like what you've earned. Always, always, always. But when we've talked about, bonuses, not overtime, but bonuses, the commissions, maybe you have unpaid PTO. Some states, they're required to pay you out for that PTO. Other states, they're not. So back to that definition of what are you going to get paid out on? That is something that once you define that and it's clarified, there's no going back on that. You can't sue for that. Okay. My agreement says that I can't work for any competitor in the industry. Is that normal? Yes, but we can do better. So any competitor in the industry, that is the whole point of a non-compete. Competitors. You can't go to a competitor. That's how these all started. And it makes sense. You don't want to take your processes, your trade secrets. Even if you're just a sales employee, you know their client list. You know when those client agreements are up and all this. That's all insider info, right? That's behind the scenes insider info. So when you go to one of their competitors, you're bringing that with you, even though it's not malicious intent or you're trying to undermine them or anything. It's just, you know stuff. You learned it there. And you're smart. You have this in your brain. So it is normal for them to not want you to go to their competitors. What's difficult here is, what does that mean? A competitor. So I like to recommend my clients get a list from them and explicitly state in the agreement, you're not allowed to go work for these employers in these types of roles. Here's why. One, a competitor, what that is will change over time. What a competitor is will change over time. Other companies might merge their way into this company's, your current employer's space. Your current employer might spread it to other. What is a competitor changes over time. Second, so you want to limit that list, right? Now you know that list and it's time stamped. So if that changes over time, your employer doesn't get to come along and be like, well, you said 2 years ago you signed a 2-year non-compete that you wouldn't work for a competitor. And you'd be like, well, they weren't a competitor at that time, but they are now. So I like to get that list. The second thing is the roles. Why does the roles matter? Here's why. I've worked for Fortune 500s, multiple divisions. Every division has a completely different product line or a different part of the industry, how we did things, what we did, and what the laws and compliance were. So when you have a lot of big companies like that, what you're saying by saying you can't go to any of our competitors is that you can't work in any of their divisions. If I only worked in division 1, why can't I go work for your competitor in division 4? There's no overlap, but it works. But the name at the top, the company name is a competitor. You can't go there. So I want that narrowed down for you, especially if you're dealing with larger businesses in your industry, is that it doesn't matter if you work in a different division. It has nothing to do with the other one. But you said you want to work for a competitor, so they can say, well, this company competes with us in this division. We don't want you there at all. I'm like, come on. So that's what I like to recommend for non-competes is get it clarified, get it narrow, and get it like something limited to today, not what might happen with either company in the future. Because I don't know about you. I haven't figured out, but I have not figured out how to predict the future yet. I think there was one more question. Can the company really take back my severance after they pay it? You're signing a contract. You're signing an agreement. And this is agreement, like I said, it's not required by law. So everything in this is what you're negotiating. Once you sign that, you've agreed to it. And if you've agreed to them taking that money back for whatever those reasons are, the answer is yes. Yes, they really can come take it back and it would be legal because it's what you agreed to in the contract. 100%. Okay. So, hey everyone, ceolegalcoach.com/severance-agreement. I've got a number of articles there. And of course, if you're interested in the Severance Studio where I break everything down, I even have some extra exercises, bonuses, and videos in there. But it covers money matters, a whole video, checklist and guide on that. Covers the insurance matters, what to expect, how that's going to go, video, guide, and checklist on that. Then we also have the waiver of rights, like what are you giving up, this versus that. And what is the other thing? Oh my gosh, there's more in there. There's 4 main modules, and then there's some extras to make sure that you have a full checklist and you're not going to miss anything major or that's important to you in your severance agreement. Tomorrow we go live again, 10 a.m. Pacific time, and we are talking about what to negotiate. What key areas do you want to be negotiating? Today was about the red flags. What key areas can you negotiate? Can't you negotiate? We're going to talk about it